Is there any public comment under this? Okay. Looking for a motion. Commissioner Cook?
Move to approve ordinance number 2015-26.
Second.
I have a motion to approve ordinance number 2015-26, GEN 15075, amending the Northport City Code Part 2, Chapter 2 by Commissioner Cook, seconded by Commissioner Jones. Any discussion?
We've gone through this. We've gone through workshops. We've addressed this issue over a year ago when the other city attorney was here. So I'm grateful to the present city attorney for having brought it all together and cleaned up the language, and I'm looking forward to moving forward on this.
Thank you. Commissioner Jones?
No.
Commissioner Yates?
I have a couple of questions on this. City Attorney mentioned just a few minutes ago that this ordinance in front of us it is eliminating the two offices, that this ordinance, that's what this does. So I just ask you, where in this ordinance does it address two other offices or merging of an office? Where in this ordinance is any of that as far as the intent in here? Can you show me in this ordinance where that is?
I beg your forgiveness. The question is to show in the ordinance where it does away with the hearing officer and does away with the special magistrate?
Yeah, you mentioned that this ordinance was for the liens and so on, but then you talked about the fact that we have two offices, and this basically alleviates that, eliminates the two offices.
Yes, ma'am. If you look on your screen, Section 2, what this ordinance is doing is it's striking out special magistrate and it's adding hearing officer system.
Okay. And previously, in the previous meetings, as well as in some questions that were answered, it was confirmed that basically all that is doing is changing name special magistrate to now name hearing officer. So I get that. I get that this is changing the title from special magistrate to hearing officer. What I'm asking is, subsequent to that, where is this ordinance then basically saying that this code enforcement hearing master is eliminating the zoning hearing office master? As you were talking about, that's what this ordinance does.
If I represented that this ordinance was doing away with your zoning board of appeals officer position, I misstated. I apologize for that. That is not what this ordinance is doing.
Okay, that's what I wanted to clarify. Okay. I have a question in regards to the unsafe, the added language on page 9 of the strike-through version.
Yes, ma'am.
Okay. That section E talks, section D is new, and it's being added specific to the unsafe building abatement. So my question is, right now in the code in it's chapter 2 and section 42 actually specifically addresses abatement and building abatement or nuisance abatement and that kind of issues. When we go in and have to repair, there's a pool, has no cage, we have to do something. And that process, those things that are addressed by staff, because they're going on the property and doing some things, it's a special benefit to the property, and we actually utilize the special assessments for those. So we want to make sure that that is correct.
Correct.
Okay. So if we've already got that in place, my question then would be, I mean, for all these years, we're trying to figure out how do we deal with these issues. We've already had it in the code. Why have we not been utilizing that mechanism?
The first mechanism that you referred to is an extraordinary remedy for government. The government is actually, could potentially be argued that the government is seizing property. That is repugnant to many in your city. It is an extraordinary remedy that the government has when it must act for life safety, health, welfare issues. For other items such as somebody's living without sewer or water and it's unsanitary, doesn't necessarily rise to the level that the government must act. This provision that's being proposed to you is a remedy or is a method that the government has that the fine will gradually accumulate. The property owner will know about it and will be faced with the position of, I either pay the fine or I connect to this, or I get sanitary water and sewer.
Okay, so is this supplemental to the other process?
Maybe alternative.
Okay, alternative. Okay. And so one of the things about this one where it says unsafe, we have obligation, as you were kind of talking about. If there's an unsafe situation, we have to address that. And so from conversations, I've spoken to staff about this, what I got from that was, and as you just said, if there's an unsafe situation, this goes in place, the fine accumulates, and then we can go in and take action, whether it's foreclosure, sue, or what have you. In those instances, my concern is sitting back and waiting and taking 6 months or however long it takes to go through that particular process. We're talking about something that's unsafe. And so the question that comes to mind is responsibility and liability of the city, that if we've identified something unsafe, that we're not utilizing the power and ability that we have already to go ahead and mitigate that circumstance. And kind of the special assessment is the special benefit to them that those things are taken care of, so that's able to be even put on the tax so that we can collect those for certain. So I'm sharing my concern, so hopefully you can help respond to that as to, is this meant more for unfinished buildings or something? It's the word unsafe that's in here that's giving me some real concerns in this scenario.
Your intuition is excellent. It's going to be a balancing act. You're absolutely. There's going to be times when the city will act, will have to act, and then there are other times where time is not of the essence. It will be a balance.
Okay. And if we were to utilize the other chapter 42, and I have looked at other city codes as well, the standard unsafe building code that allows for that abatement, allows for whatever the costs were for demolition or what have you, repair, to be put actually on the tax bill. And if they don't pay that, then their property basically becomes to where, they've got a tax lien now on it and they can lose it. So in these circumstances, again, the word unsafe, should that be more of unfinished?
Are you asking should the word be changed from unsafe to unfinished?
Yes, because of what I'm bringing up as far as the liability and the responsibility and so on.
Well, can I ponder that and see if Scott has something to add?
Scott Williams, Neighborhood Development Services Director. Unsafe is defined already in the Florida Building Code, and I think it's proper language. I don't think unfinished would. And to address the unsafe building abatement process, we have utilized that. The unsafe building, if it's an immediate threat, we already have somebody go out. We post it as an immediate threat. We have somebody go out and take care of that particular concern without any additional notification requirements, and that's all as per the unsafe building abatement section, Chapter 1 of the Florida Building Code. So we do utilize it, and as the city attorney, alluded to, this gives an opportunity or an alternative. And once again, I've pointed out several different times that an unfinished building and you know that you've seen plenty of them around the city that are completed with the exception of windows and doors and that type of thing. Would I consider an immediate threat? Probably not. And we can make it safe. It isn't an unsafe condition. Should be high winds come up or come into play. So the alternative then gets to be a cost factor of the valuation of the building versus the property values. So our action in those cases is to go in and plywood the doors and windows and openings to make them safe. That doesn't take care of the valuation problems of the neighboring properties, and probably the biggest complaint that we get.
But in that scenario that you just mentioned, and going ahead and doing that, which we have already the ability to do, and I guess has been done before, are we utilizing the ability of that special assessment lien to recoup the money, and be able to rectify the situation?
There are two different processes. The unsafe building abatement is clearly defined on the steps and procedures and notifications required to go through that. Anytime that we do that, then yes, a lien is put in place on the property. So eventually, hopefully you see the return on that. But I would say that's not real good. Once again, this gives another level, or ability or tool, as the city attorney has stated, to take action. And I don't know, and I double check with the city attorney, but I don't know that those two items could not run simultaneously. So you're taking action in the board, to take care of the long-term problem, and taking the unsafe building to take care of immediate issues that are unsafe conditions. And I like that ability.
Okay, but we're not using the tax collector right now to collect those. Once they go unpaid for so many months, we're not using that ability.
Well, we always have that ability, but
we're not using it.
Well, again, we haven't been in that situation that I'm aware of yet.
Okay, so it hasn't been utilized, I guess, if we're not in that situation. Okay, I think I got to my point on that one. If, city attorney, if we took this route versus the other, and then moved to sitting and waiting for this unsafe thing to accumulate fines and then go to foreclosure, in those scenarios, would we not, as what happened when the police confiscated basically a home and then found that there was the mortgage on it, and then the city basically had to turn over the property because the mortgage was more than the property? Could this not present similar scenario for the city, where we sit back and we wait for liens to accrue, and then there's unfinished, there's construction liens, there's mortgages, there's all of those things that if we move forward and go ahead and foreclose on that property, we, the city, then not only would not get monies that we have taken action to abate, but we also basically would end up being stuck with the bill to pay off all of those other entities. Could
Yes.
that, I mean...
Yes.
Okay. Okay. All right. That is all the questions I have, so then I'll get to the discussion.
Okay, hold on. I want to clarify something. Under your discussion of D, when you talk about unfinished versus unsafe, you're talking, as I see it, as government intrusion versus property rights. As when you talk about unsafe, absolutely we're going to have to intrude because there's a safety to health and safety to others. When you're talking about lesser where it's not unfinished, is what you're talking about is unfinished, you're stepping into property rights. So I'm perfectly all right with the verbiage that you have on D, and absolutely have no problem with that, because I do understand the difference between government intrusion and property rights. So I'll leave it at that. Is there any other commissioner that would like to speak? Because Commissioner Yates will be speaking first, and I'm giving you the opportunity prior to Commissioner Yates. Nobody else? Okay, shoot.
There's two other questions that were not answered. There was between staff. But one is on that same page that we were on, the $5,000 per violation for the violations that are irreparable and irreversible. That line is stricken, and that state statute 162 specifically calls out those scenarios because they have different caps. They have that could be charged to somebody for a per violation charge. So my concern and question is, why is that being stricken? And both staffs independently said they didn't know, so hopefully we can get that answer now.
I did, Your Honor, and when I consulted with staff, he prompted my recollection, and the issue that I was having with it is if you come down to 5 of that section, it provides maximum caps. The commission has said the maximum cap for a unified land development code is going to be 2,000, 5,000 for the Florida Building Code, 1,000 for any other. So then when you try to reconcile that with D, where it says 5,000, I was just anticipating being in front of a judge and having my opponent say, Judge, the commission under B has capped it. So the 5,000 per violation for a violation that is irreversible in nature, what's that? And I would be hamstrung by the language that would be found in section 5, A, B, and C.
Okay, so so long as, I would imagine, so long as that doesn't fall into the unsafe abatement, where it was irreversible or irreplaceable, because there's no cap on that category, and however the state does put a cap on it. So I understand what you're saying, but that's being mindful that if there is an irreversible or any irreversible or irreparable type of thing that falls into the unsafe category, that those may not be charged anything in excess of 5,000, even though it says there's no cap. I just want to be clear that
Understood.
Is the way it's. I mean, it doesn't say it. I always think it's best to say things in the code, but so long as it's not going to exceed that or go beyond that in those particular situations. The other, if you could stay, will you still? Okay, if you could go back up.
I'm sorry.
The one area of this that I asked about is that where it says in item E, this is talking about additional fines for repeat violations. So where the word additional is in there was concerning because, and even in our conversation when we talked about this, it could be basically looked at that that's going to be in addition to the daily fine. However, when I got a response on the question, it was, no, that's in lieu of. So the word here where it's talking about may impose additional fines for repeat violations, if that's meant to be that if any kind of repeat violation is going to be, period, $500, doesn't matter if it's Florida Building Code, doesn't matter if it's the ULDC, doesn't matter if it's any other code, if it's a repeat, it is going to be $500, not in addition to the daily fine.
Correct.
So does the word additional fine need to be removed?
I see your concern about that. That the additional fine is ultimately it's going to be a matter for the magistrates. The gravity of the violation, I can share with Commission that how that gets applied is additional fine, meaning not $250 plus the $500. Additional fine meaning if $250 is your cap, if you're a repeat offender, you're going to have an additional fine of $500. So I'll yield to however, I mean, if you think it would.
I'm just asking, it says additional, so that to me means you could be charged the $50 a day, $250 a day, $10 a day, in addition to the $500. And if that's not what it's meant, then I'm just seeking clarity. So, for example, in the state statute, it says first-time violations are so much, second-time repeat violations are this much. So it just separates those categories. And that's all I'm seeking is clarity.
Would Your Honor be content with just striking the word additional?
That's something that if the commission has consensus to do.
Hold on. She has the floor. Are you looking for a consensus from everybody else, or just a clarity of that?
Well,
'Cause he can certainly bring it on the second.
This
is the second.
This is
This is the second. That's right.
That's why he's asking, and if this is something that the commission agrees to clarify to where it is meant to be, that is the fine for a repeat violation. It's not in addition.
Okay. You're looking for a consensus?
Yes.
Commissioner Cook?
I'm perfectly fine with the way the ordinance is written by our city attorney.
Commissioner Jones?
I'm fine with it.
Vice Mayor?
I'm not sure I really understand. Could you just revisit when it is with or without the word additional? How does that apply to the 500 a day, please?
in A, B, and C, Vice Mayor, the daily amount of fine is provided. If you come down to
D.
E, if you are a repeat offender, in other words, we've already found you in violation of something before, and now you're in front of the magistrate a second time for the same violation, the fine can be as high as $500. The matter of discussion right now is the word additional. Is it $25 plus $500, or is it just a flat $500? Or, is it $25 plus $500? Is it $50 plus $500? Is it $10 plus $500? Or for repeat offenders, is it just going to be $500 per day?
And in the way it's written, is it meant to be just 500 a day?
Yes. What I see your colleague's argument.
I can live with the word additional taken out.
Okay, that leaves a 2-2. I do have a little bit of a problem in the verbiage in regards to. I do understand that you have, the fines that are imposed, and then the hearing officer comes in and he sees that this is a repeat offender that keeps coming back, because we've seen this in Northport. So what we're saying in this E is that it cannot exceed 500, and then right afterwards you're saying such fines he can impose additional on top of 500. So that's the way I'm reading it, but yet you're still saying in the first sentence he cannot exceed. So that's where the clarity issue is up, and I would like, for you to present the clarity. So, yes, you have a consensus.
Consensus is 5. I'll make a motion if you'd like, so that we can.
A motion?
To amend.
To amend?
Yeah.
Okay.
I can do it that way.
Can you make it
very short?
A straightforward amendment, please?
Sure. I'll move to amend section number 2-5511.
25511?
Yes. 2511.
2511. Section E?
Section B1E.
Go ahead.
To remove the word additional.
Okay, I have amendment by Commissioner Yates to amend 25.11, Section B1E, to remove the word additional. Do I have a second?
Second.
Seconded by Vice Mayor. Discussion.
I think we talked about it. I'm not.
I do have a question. By removing additional, is that going to change any issues in regards to legality on the defense of the hearing officer adding any additional fines?
I can't foresee any at this point.
Okay, thank you.
So, Mayor, for clarity?
Yeah.
In removing the word additional, I mean, I'm not going to strap staff's hands in wording that appropriately.
Right.
You know what I mean? So they may have to introduce it as repeat violations shall not exceed $500 a day. So I'm not going to, I don't mean to strap your hands. It's just the context that we're trying to remove is the word additional. So,
Okay, let's move on.
okay.
Call for the vote on the amendment. And that passes 4-1 with Commissioner Cook dissenting. Commissioner Cook, do you want to, any comments in regards to the dissent? To put on record, thank you. Let's move on to
Can
the.
we- I still have another question.
You're way over time.
For questions?
Well, it's all comments and questions.
Oh, it used to be
You're-
questions
you're
and
saying-
then discussion.
No, it wasn't. It's always been, since I put it in play, that it's comments and questions at the end. You got 2 shots at it. You're way over. We need to move on. We've got a motion on the floor.
Okay.
So let's move on with the motion.
I'd like to make some comments then if my questions are going to be cut off. So-
You've been at this a while, Commissioner.
This is a hearing, this is an
always
ordinance, Mayor.
a problem with you every meeting. You know, it's 2 10-minutes. You know it. Everybody knows it. It's not fair to the other commissioners that you spend an hour on discussion and questions. Time management. That's what it's about.
And the
Okay?
gravity of the importance of the
Let's-
issue
let's move on with the vote.
is very important.
Let's move on. We've got a long agenda.
I get
We're going to
that.
end up doing this every item.
These are
Call for
important
the vote.
issues. Mayor, I would just ask for a point of order that you.
What's your point of order?
My point of order is I have a lot of comments and questions and even some clarities that the city attorney has provided 2 answers to me that yes, they need to be addressed.
I'm calling the
And-
question
So
at this point.
if you want a motion to call the question, and then so be it. But again, I will submit everything to the clerk's office for the reading file, for the public record, because these are issues that are very important.
Certainly, you
And
can-
whether it takes an hour or 2 hours or 5 hours, putting a law in place, to me, we need to take as much time as what we need to.
Certainly, we'd be here till midnight, Commissioner.
If that's what it takes, I'm fine with that.
Yes, it's called decorum. Let's call for the question. I'm calling for the question, so that calls for a vote.
Are you making a vote to, a
Yes.
motion? You're making a motion?
I'm making a motion. I call for the question.
Okay, because typically, point of order, mayors, chairs do not make the motions. So
Point of-
in order to shut the debate down, I would just ask to, if somebody wants to make a motion to do that and we take a vote on that, so be it.
Point of order. I call the question.
Okay, there you go. There's a motion on the floor by Commissioner Cook to call the question. Do I have a second?
Second.
Okay, I have a second by Commissioner Jones.
It
Call for the vote.
requires no second.
That's right, it doesn't. So go ahead and call for the vote. There's no debate on that, by the way. And that passes 4-1 with Commissioner Yates dissenting for statements mentioned.
And I'll submit it to the clerk as well.
Absolutely. So let's go on to the main motion to approve ordinance number 2015-26, GEN 15075. Go ahead and call the vote
As amended, right?
as amended. And that passes 4-1 with Commissioner Yates dissenting for reasons as stated. All right, let's move on to public hearing B, 14-1203. DM 15083, amendments to the pattern book for the development of Herring Creek Town Center. This